4,400. I've been sitting with this number in the briefing materials for about an hour now, just staring at it.
It is a heavy number.
Yeah.
It's one of those stats that almost feels like a typo at first, you know?
Right, because in the context of federal litigation, it's statistically improbable.
It really is.
That's what I couldn't wrap my head around. If you look at the track record of federal agencies, I mean, whether we're talking about the EPA, the IRS, the SEC, when they get taken to court on procedural grounds, the government usually wins.
Oh, overwhelmingly.
They have the resources, they have the presumption of regularity, and they have the statutes on their side. But here, we're in February 2026, and we have a report stating that in a window of just 5 months?
Since October, yeah.
Federal courts have ruled against a single agency, ICE, 4,400 times on the specific grounds of illegal detention.
We need to be really clear right off the bat. That isn't 4,400 administrative errors.
No.
That isn't 4,400 instances of, oh, you filled out the wrong form or you missed a filing deadline.
Right. These are habeas rulings. These are federal judges looking at the Department of Homeland Security and saying, you do not have the legal authority to hold this human being. Full stop.
Which brings us to the core friction of this deep dive today. We are looking at a paradox. You have the agency tasked with the supreme enforcement of the border.
Operating under this strict control mandate that has defined the last year.
Exactly. And they are effectively operating in a state of continuous high-volume conflict with the judiciary.
It's a constitutional stress test. You know, we often talk about checks and balances as this abstract high school civics concept. But what we are seeing in these documents is the gears grinding. The executive branch is pressing the accelerator on detention, and the judicial branch is just slamming on the brakes.
And the result isn't just sparks. It's a systemic failure. It's a massive traffic jam in the justice system.
And it's important to frame the timeline. We are in February 2026. The aggressive expansion of detention facilities, the so-called surge capacity initiative, that's been running hot for about 13 months now.
All right, we're past the implementation phase. We're deep in the consequence phase now.
So our mission today is to take apart this machine. We need to look at the logistics of that surge. How do you physically detain 75% more people in a year?
A 75% increase. It's an astonishing number.
We need to analyze the legal arguments. Specifically, why the courts are losing patience and ruling against the government so consistently. And we have to look at what you call the clot.
The clot.
The massive logjam this is creating in federal dockets that, and this is the key part, affects everyone, not just immigrants.
It is a messy, complex picture. But it explains why, if you walk into a federal courthouse today, the tension is, well, it's palpable.
Let's start with the context then, because it is February 2026. The news cycle is dominated by this, but I think the nuance, how we got here, often gets lost in the headlines.
It always does.
We need to understand the agency itself, ICE. It's an acronym that carries a lot of weight, a lot of political baggage, but I think people often forget the structural history here.
I think you're right. It's incredibly young in the grand scheme of federal bureaucracy. It was born out of the Homeland Security Act of 2002. And it was officially activated in March 2003.
So it's a post-9/11 creation, through and through.
Through and through. The DNA of the agency is counterterrorism, national security.
Right, which is a very different starting point than its predecessor.
Completely different. Before 2003, we had the INS, the Immigration and Naturalization Service, which was under the Department of Justice. And it was a classic dual mandate agency. It handled both services and enforcement.
The person who stamped your visa application worked for the same overarching agency as the person who might arrest you for overstaying it.
Exactly. When DHS was created, they split the atom. USCIS, U.S. Citizenship and Immigration Services, took the services part, the visas, the citizenship applications, the green cards, and ICE, Immigration and Customs Enforcement, took the enforcement sword.
And even within IC, there's a critical split, right? It's not one monolithic thing. You have HSI and ERO.
That's a crucial distinction that gets missed all the time in the public conversation. You have HSI Homeland Security Investigations, which focuses on major transnational crime. Think cybercrime, human trafficking, intellectual property theft.
These are the federal agent types you see in movies, investigating complex criminal networks that happen to cross borders.
Precisely. And then you have ERO enforcement and removal operations. And their job is, well, it's in the name, interior enforcement, detention, and removal of undocumented immigrants.
And the source material for today makes it very clear. The story of 2026 is the story of ERO becoming the dominant, overwhelming force within the agency.
It is. The strict control policy has effectively poured unlimited resources and political capital into the ERO side of the house.
So the mandate shifted. For a long time, there was at least a balance, or you could say a tension, between investigating those big HSI-style crimes and managing the undocumented population.
Yes. But under the current administration, the strict control policy has tilted the scales almost entirely to interior enforcement and removal. It's a volume business now.
Strict control. It sounds like a campaign slogan, but in practice, it's an operational directive. What does that actually look like on the ground? Is it just tougher talk, or are the mechanics different?
Oh, it's deeply mechanical. The sources we've looked at indicate that this policy has translated into what are, for all intents and purposes, quotas for arrests.
Even if they don't call them quotas.
They will never use the word quota. They'll call it performance metrics or enforcement targets. But the pressure is on regional directors to increase the volume of apprehensions. It's a numbers game.
And when you prioritize volume, just getting the numbers up, what happens?
You inevitably cast a wider net. And when you cast a net that wide, that quickly, you start catching people that the law says you shouldn't be holding. Or you start holding them in ways that violate procedure because you're moving too fast to do the paperwork.
Which brings us to the surge numbers. Let's look at the population statistics provided in the source, because they are. Honestly, they're kind of mind-blowing.
They are. Let's just focus on the daily detention population. As of right now, February 2026, there are approximately 68,000 people in immigration detention on any given day.
68,000. Just let that number sink in.
To put that in perspective for you, throughout most of the early 2020s, the average daily population hovered between, say, 20,000 and 35,000.
So this is double, in some cases almost triple, the historical average.
Hitting 68,000 isn't just growth, it's a metamorphosis. It's a 75% increase just since January 2025, in 1 year.
Okay, let's unpack the logistics of that. A 75% increase in a year. If I had to expand my house by 75% in a year, it would be total chaos.
Right.
If a business had to expand its operations by 75% in a year, supply chains would break, quality control would vanish. How do you even house, feed, and process that many new people that quickly?
Well, you can't just build a new federal prison in 6 months.
Of course not.
And you're touching on the logistical nightmare and really the source of so many of these legal problems. You don't build new federal facilities. That takes years of appropriations, environmental impact studies, and construction.
So where are they putting everyone?
To scale this fast, ICE has relied heavily on rapid acquisition contracts.
Which means private prisons.
Private prisons, yes, that's a big part of it. But also, and maybe even more significantly, intergovernmental service agreements, IGSAs, with county jails.
So explain what that is.
Essentially, ICE goes to a county sheriff in a rural area who has spare beds in their local jail and says, we will pay you a per diem rate, say $120 per person per day, to house our federal detainees.
So you have this decentralized ad hoc network of county jails suddenly acting as federal immigration holding centers.
Correct. And for the sheriffs, it's a huge source of revenue. For ICE, it's a way to get thousands of beds online almost overnight. You also have the soft-sided facilities, essentially high-tech tent cities springing up in border sectors to handle the overflow.
And this has to explain the warrantless detention issue we're going to get to. When you prioritize speed, when the metric is just beds filled, the due process paperwork inevitably lags behind the physical intake.
That's it, exactly. The infrastructure of confinement scales much faster than the infrastructure of law.
That's a great way to put it.
You can rent a jail cell with a phone call and a contract in 24 hours. It takes months, sometimes years, to hire, train, and vet a new immigration judge. It takes time to train ERO officers on the nuances of probable cause for arrest.
And that delta, the gap between the speed of arrest and the speed of adjudication, that's where the illegality breeds.
It's where the whole system starts to short circuit.
And that leads us directly into the legal battlefield. Because illegal detention sounds bad, but I want to know specifically what that means. The courts aren't just saying, we don't like this policy. They are saying, you are actively breaking the law.
Correct. And to understand the sheer scale of the resistance, we have to look beyond just those 4,400 rulings. The source also mentions that there have been over 20,200 habeas corpus requests filed by detainees.
20,200. Okay, let's wade into the legal weeds here because this is important. A habeas corpus petition. Habeas is known as the Great Writ. It's the break glass in case of emergency provision of the Constitution. But let's define it properly for our listeners, because it's more than just a request for release.
It is the most fundamental right in Anglo-American law. It comes from the Magna Carta. It's in our Constitution, Article 1, Section 9, Clause 2. The privilege of the writ of habeas corpus shall not be suspended.
Unless when, in cases of rebellion or invasion, the public safety may require it.
Exactly. It is the mechanism by which a person can challenge the jurisdiction of their jailer. You go to a court and you say, show me the body, which is the literal translation, and show me the legal reason you are holding this body.
So it's not asking the court, am I guilty or innocent of an immigration violation? It's asking, does the government even have the power to put me in this box right now?
Precisely. It challenges the legal basis of the confinement itself. Now, normally, habeas is a last resort. It's what you file after you've exhausted all your other options.
Right. There's a whole separate court system for this, the EOIR, the Executive Office for Immigration Review. You're supposed to go through their process first.
Yes. You have your master calendar hearing, your individual merits hearing, your bond hearing. You can appeal to the Board of Immigration Appeals. There's a whole administrative ladder to climb.
So the fact that we are seeing 20,200 habeas petitions being filed in federal district courts, Article 3 courts, that tells us something critical.
It tells us the administrative line is dead. The ladder is broken.
The detainees aren't waiting for the immigration courts. They're going around them.
They're bypassing them because the system is completely collapsed under the volume. If you are legally entitled to a bond hearing within, say, 10 days of your arrest, but the immigration court can't schedule you for 6 or 7 months,
then your detention has effectively become indefinite.
It has. You have been deprived of due process. So your only option at that point is to knock on the door of the nearest federal district judge and say, my constitutional rights are being violated right now.
And clearly the district judges are answering the knock. 4,400 rulings in favor of the detainees. Let's break down why they are ruling this way. The source categorizes the illegality into 3 main buckets. The first is warrantless detention.
Right. And this creates a significant Fourth Amendment friction point. In the regular criminal justice system, if the police arrest you without a warrant, they generally have 48 hours to get a probable cause determination from a neutral magistrate. That's the standard from a Supreme Court case, County of Riverside v. McLaughlin.
But immigration is considered civil, not criminal. So does that 48-hour rule apply?
That is the subject of intense litigation right now. The government argues it doesn't, that they have more leeway. But even if you allow for a slightly longer window, what the courts are finding in 2026 is that people are being held for weeks, sometimes over a month, without a warrant or even a charging document, the notice to appear, or NTA ever being filed with the court.
They are being ghosted into the system.
That's a perfect term for it. ICE picks them up maybe during a worksite raid or a traffic stop. They transport them to a contracted county jail. And then, because the paperwork backlog at the regional ER office is so bad, they just sit there.
So there's no official record of their detention in any court system?
For a time, no. No judge knows they're there. No lawyer knows they are there. The warrant, the legal justification for the arrest and detention, is missing in action. And federal judges are saying that is a fundamental violation of the Fourth and Fifth Amendments.
That is terrifying. Just the idea that you can be grabbed off the street and the paperwork doesn't catch up to you for weeks. Okay, the second bucket the source identifies is denial of bond.
And this ties directly back to the backlog we just talked about. Under the law, and specifically under Supreme Court precedents like Zedvitas v. Davis, the government cannot detain someone indefinitely for a civil violation.
There has to be a light at the end of the tunnel.
There has to be. If their deportation isn't reasonably foreseeable, or if the person isn't a danger to the community or a flight risk, they should generally be eligible for release on bond while their case proceeds.
But the strict control policy seems to be interpreting flight risk very, very broadly.
Extremely broadly. The administration's position is essentially that everyone is a flight risk by virtue of being undocumented. But the courts are pushing back hard on that. They're saying you can't make a blanket determination. The law requires an individualized assessment.
You have to look at their ties to the community, their family, their work history.
All of it. And more importantly, the courts are finding that ICE is simply refusing to schedule the bond hearings in the first place. It's detention by delay. By clogging the dockets, they make it impossible for people to even ask for bond. And judges are calling that a violation of due process.
And the third reason, this was the one that, this really signals a constitutional crisis to me. Defiance of court orders.
This is the most volatile part of the report, without a doubt. We're seeing a pattern of cases where a federal judge has looked at the evidence, heard the arguments from both the detainee's lawyer and the government, and issued a specific unambiguous order saying, release this person.
And
IC just doesn't.
Wait, let's unpack this. How is that even possible? If a judge says, release him, and the agency holding him says no, isn't that contempt of court? Isn't that illegal?
It is absolutely unequivocally illegal. It undermines the entire authority of the judiciary. If the executive branch can simply ignore a judge's order, then the checks and balances of our democracy are broken.
How do they do it? They can't just tell a federal judge to get lost.
No. But practically speaking, ICE has the physical keys to the cells. So they engage in what you could call bureaucratic rolling the federal banks.
Bureaucratic rolling. I like that.
They don't send a letter saying we refuse. They'll say we are processing the order, or there are additional security vetting protocols that supersede the release order, or we need to verify the release address. They use administrative friction and red tape to delay compliance for weeks, sometimes months.
But the sources mention cases where detainees remain in custody for 90 days after a federal judge ordered their release. That's not a delay. That's defiance.
It is, and it's inching terrifyingly close to a breakdown of the rule of law. If a court order is treated as a suggestion by the police power of the state, the judiciary loses its teeth.
And that explains why these judges, some of whom are very conservative, appointed by this same administration, are ruling so forcefully against IC.
Exactly. They're protecting their own institutional authority. It becomes less about immigration policy and more about the fundamental power of the judiciary to enforce its own orders.
It feels like a standoff, a slow-motion constitutional crisis playing out in courtrooms and detention centers. But before we get too abstract with the legal theory, we need to remember that these aren't just case files and docket numbers. These are people.
Right. And that brings us to the human face of these statistics. We can get lost in the numbers, 20,000, 68,000, but the source material highlights a couple of case studies that really bring this home. The first is a high school student from Venezuela.
Let's walk through his story because it illustrates all the mechanics we just discussed.
So this was a young man, a senior in high school, described as a good student, on track to graduate. He was detained following a routine traffic stop.
A traffic stop, so a broken taillight, speeding. What was the infraction?
A rolling stop at a stop sign. In a different era, or under different policies, this results in a ticket, maybe a warning. But because of the strict control mandate, local law enforcement in this specific jurisdiction had what's called a 287G agreement, or a similar cooperation agreement with IC.
Explain 287G quickly for us.
It's a section of the Immigration and Nationality Act that allows DHS to deputize state and local police officers to enforce federal immigration law.
So the local cop who pulls him over for the stop sign is also, in that moment, acting as a federal immigration agent.
Effectively, yes. So the officer runs the student's license. It comes back with a flag indicating he's out of status. Instead of writing a traffic ticket, the officer holds the student. IC is notified and places a detainer on him.
Which is a request to hold him for up to 48 hours until IC can come pick him up.
Exactly. And at that moment, he leaves the local criminal justice system and enters the federal civil immigration system. He's transferred to an ICE detention center.
And here is where the strict control policy creates the tragedy.
Absolutely. This student has no criminal record. He's attending school. He has ties to the community. In previous years, he would have been a quintessential low-priority case. IC might have used prosecutorial discretion to let him go with a notice to appear in court later.
But not now.
But under the current zero-tolerance, numbers-driven approach, he is processed for detention. He's a number to help meet a metric.
And because of the backlog, the clot we discussed,
He sits there. He can't get a bond hearing. He misses his final exams. He misses graduation. He loses his part-time job. His family can't find him for days. He becomes one of the 20,200 habeas petitions because it's the only way to get a judge to even look at his case.
the implication here is huge. We're not talking about a raid on a criminal syndicate. We're talking about the threshold for losing your liberty being lowered to a rolling stop.
It illustrates how routine, everyday encounters with the state are escalating into federal detention scenarios. And it's not just individuals. The sources also point to families and children being detained.
This touches on the Flores settlement agreement, doesn't it? The long-standing court order that sets standards for the detention of minors.
It tests the absolute limits of Flores. The government's position is that they are detaining families together, arguing that keeping the family unit intact justifies the detention of the minor child.
But Flores generally says you can't hold kids in jail-like settings for more than 20 days.
Correct. But they are using these family residential centers, which they argue are not jail-like. But the crucial detail here, again, is the lack of criminal records. These are often asylum-seeking families who presented themselves at the border, or families swept up in these broad interior enforcement actions.
So if you're listening to this and thinking, well, if you don't break the law, you have nothing to worry about, these cases really challenge that narrative.
They do. These are people caught in a dragnet that is designed to meet a volume metric, not to target specific threats.
If the metric is bodies in cells and you demand a 75% increase in 1 year, you run out of bad guys, people with serious criminal records, pretty quickly.
You do. To keep the numbers up, to satisfy the metrics, you have to start arresting the student at the traffic stop. You have to start detaining the family with no record. The policy itself necessitates these kinds of arrests.
That is a chilling thought. The quota drives the profile of the person being arrested, not the other way around.
It's a classic, and in this case tragic, example of metrics driving behavior.
Okay, I want to push back on this for a second, though, and play devil's advocate. We're painting a picture of a rogue agency run amok. But the administration and a significant portion of the electorate would argue that ICE is doing exactly what it was told to do by Congress.
And that's a fair point to raise. What's their argument?
Well, look at the mandate. Strict control. The argument from the White House and the Department of Justice is that the immigration laws, the INA, the Immigration and Nationality Act, are mandatory, not discretionary. They would argue the previous administrations were the ones breaking the law by using prosecutorial discretion to not enforce it.
Catch and release argument.
Exactly. They say this administration is the one finally enforcing the letter of the statute. If the law says shall detain for certain categories of individuals, and they are detaining them, aren't the courts the ones who are overreaching and changing the rules?
That is the strongest argument the Department of Justice has, and they are making it in court every single day. They rely heavily on the Supreme Court's long history of deference to the executive branch on immigration matters.
Immigration has always been seen as a core executive power tied to national sovereignty.
It has. And they cite cases like Jennings v. Rodriguez to argue that these statutes do not mandate bond hearings in the way activists and some lower courts claim.
Right, Jennings. That was the ruling where the Supreme Court said the Ninth Circuit couldn't just invent a 6-month time limit for detention out of thin air. The court said Congress has to make that rule.
Exactly. So the administration is standing on Jennings. They go into court and say, look, Your Honor, Congress wrote the law. The law says detain this person until their removal proceedings are over. If those proceedings take 2 years because the courts are backed up, that's not our fault. That's a resource issue for the judiciary, not a constitutional violation on our part.
They argue that operational necessity and national security give them broad latitude to manage the system as they see fit.
Yes, that's the core of their defense.
So why are they losing so often? If they have Jennings and a history of judicial deference on their side, why are there 4,400 rulings against them?
Because of the conditions and the scale. It's one thing to argue for prolonged detention when you have 20,000 people in the system and there's at least a theoretical access to counsel and the courts. It's a completely different argument when you have 68,000 people, many of whom have no access to lawyers, many with no criminal records being held in overcrowded county jails.
So the facts on the ground have changed the legal equation.
They have. The courts are essentially saying that operational necessity doesn't grant you a blank check to suspend the Fifth Amendment's due process clause. There's a breaking point. When detention becomes indefinite not by law, but by virtue of a dysfunctional system, due process is violated.
So it's the shock the conscience standard. The sheer volume and the chaos it creates is, in itself, the constitutional violation.
In many ways, yes. Quantity has a quality all its own. When you scale up detention this fast, the safeguards dissolve. The system's failures become so profound that they rise to the level of a constitutional problem. And that's what's leading to these rulings.
And this really touches on that deep institutional friction. It's not just about immigration policy anymore. It's about who gets to decide what is legal. The administration views these actions as necessary for national security. The opposing courts view them as fundamental violations of rights.
It's the classic liberty versus security debate, but it's being played out in real time in thousands of individual cases. And the administration's supporters, as you would expect, label these rulings as the work of activist judges.
We hear that term a lot, activist judge. What does it mean in this context?
In this context, they are arguing that these judges are politically motivated, that they are sympathetic to the detainees and are finding creative legal technicalities to release them, specifically to undermine the president's policy agenda.
But as you said, these rulings are coming from judges appointed by both parties.
They are. And while there's certainly some conservative judges who have issued arguments justifying this broader application of detention powers, the sheer number 4,400 and the geographic diversity of the districts where these rulings are coming from suggests it's not just a few activist judges, it suggests a widespread judicial concern about a systemic breakdown.
So let's talk about the consequences of that breakdown. Segment 5, the systemic consequences. We've touched on the impact on the detainees, the trauma, the family separation, the lost jobs. But let's go deeper into what you called the clot.
Yes. This is the part that I think affects every listener, regardless of your views on immigration, regardless of whether you ever interact with the immigration system at all.
How so?
Think of the federal court system as a highway. It has a certain number of lanes, judges, clerks, courtrooms, and it's designed to handle a certain amount of traffic. You have criminal cases, complex civil litigation, bankruptcy, intellectual property disputes, all flowing through it.
Okay.
Now, imagine you suddenly dump 20,200 extra semi-trucks onto that highway all at once, and each truck is on fire and demands immediate attention.
Total gridlock. Everything stops.
That is what is happening to the federal courts in districts with high numbers of these cases. Every time a judge has to hear a habeas corpus petition, they can't just wave it away. Because it involves someone's liberty, it jumps to the front of the line.
It's an emergency petition.
It is. So the judge has to stop what they're doing, read the briefs, maybe hold an emergency hearing, listen to arguments, and then write an opinion. That takes hours, sometimes days, of a judge's time.
And those are hours they aren't spending on all the other cases on their docket.
Exactly. Resources are being displaced. If you are a small business owner waiting for a federal judge to rule on a critical contract dispute with a major corporation, your case is delayed.
If you're a plaintiff in a civil rights case alleging workplace discrimination.
Delayed. Even other criminal trials are being pushed back. The public defenders and federal prosecutors are being pulled into these habeas hearings, which means they have less time for drug cases, fraud cases, you name it. It can even create problems with the Speedy Trial Act for criminal defendants.
So the strict control policy is effectively slowing down the entire federal court system in certain parts of the country.
Precisely.
Huh.
You cannot overload one part of the system so dramatically without clogging the whole thing. It is a zero-sum game when it comes to judicial attention and courtroom time. The Department of Justice is having to pull its attorneys off of other important defensive litigation just to show up and defend these thousands upon thousands of habeas petitions. It's a massive resource drain on the entire government.
So the policy isn't just detaining immigrants, it's detaining the administration of justice for everyone.
That is a very accurate and very sobering way to put it.
Let's widen the lens one last time then to the political landscape. We're in February 2026, an election year. How are the political parties reacting to this judicial chaos?
Predictably, it's polarized, but the specific dynamics are interesting to watch. The Democrats are seizing on these court rulings, the 4,400 illegal detentions, as their primary evidence that ICE has become a rogue agency.
That's the phrase they're using.
That's the soundbite. They're pushing for legislative reforms, for increased oversight, for slashing ERO's budget. They're arguing that the agency has become a law unto itself and needs to be fundamentally reined in by Congress.
They are pointing to the cost, too, I assume, the financial cost of all this detention.
Oh, it's a huge part of their argument. Detention is incredibly expensive. You have 68,000 people being detained at a cost of roughly, let's say, $150 to $200 a day per person.
The math gets very big very fast.
You're talking about billions of dollars a year, and they're arguing that this money is being spent on a policy that the courts are repeatedly saying is illegal and ineffective.
And the Republicans, how are they framing this?
They are standing firm on the law and order platform. They're doubling down. They dismiss the court rulings as political activism from liberal judges. To them, the chaos of the courts isn't a sign that the policy is wrong. It's proof that the immigration laws need to be even tougher.
So their argument is that the judges are the problem.
Yes. Their argument is essentially, if we had even stricter laws, if we could seal the border completely and remove people even faster, we wouldn't need to detain 68,000 people in the first place. They view the solution as more enforcement, not less. It's an issue they believe resonates strongly with their base.
And caught in the middle of this political firestorm are the nonprofits, the human rights organizations.
Yes, civil society is the third player here, and a critical one. They're the ones on the ground facilitating a huge number of these habeas filings. They're running the pro bono lawyer networks. They're the ones bringing these conditions in the detention centers to light.
So without them, we wouldn't even know about the 4,400 rulings.
We probably wouldn't. They are the transparency mechanism in a system that is, by its nature, trying to be opaque. They are the ones forcing the issue into the courts.
It really is a three-way struggle then. You have the administration pushing forward, the courts pushing back, and the NGOs and civil society fueling the legal challenges. And none of them seem to be blinking.
No. And that's why the situation in February 2026 is so volatile and so unsustainable. Something has to give.
Okay, we've covered a massive amount of ground. Let's try to synthesize this for a moment. We started with a massive 75% spike in the number of people being detained in just 1 year.
A system pushed far beyond its capacity.
We looked at the logistical shortcuts, the private prison contracts, the county jail agreements, the lack of warrants that made that explosive growth possible.
The infrastructure of confinement outpacing the infrastructure of law.
Then we analyzed the legal backlash, 4,400 rulings, and over 20,000 petitions, all pointing to a judiciary that's saying enough is enough.
A constitutional braking mechanism being applied hard.
And we ended with a judicial system that is straining, clogging up, and slowing down under the sheer weight of this conflict impacting everyone.
It is a picture of a system at a breaking point. You have an agency pushing for maximum velocity and enforcement, and a judiciary trying to apply the brakes of constitutional rights. The result is friction, heat, and a lot of human suffering caught in the middle.
The core anomaly remains, though. That's the thing I just can't get past. We have an executive branch agency continuing with practices that the judicial branch is repeatedly, and in high volume, deeming illegal.
It disrupts our basic elementary school understanding of the rule of law.
Yeah.
Usually when a court says stop, the government stops. It might appeal, but it complies with the order in the meantime.
Right.
When the government doesn't stop, or when it tries to outrun the courts by creating more chaos than the judges can handle, we are in very new and very dangerous uncharted territory.
So as we wrap up this deep dive, we want to leave you, the listener, with a final thought, something to mull over as you see these stories in the news.
We have to ask ourselves, what does it actually mean to protect a border without violating fundamental rights? Is it even possible to have strict control as defined by this administration while maintaining the civil liberties that are defined by our Constitution? Or are those two concepts, at this scale, mutually exclusive in the modern era?
And perhaps more importantly, in a democracy, what happens when the branch of government that holds the keys to the cells stops listening to the branch of government that interprets the law? Who watches the watchmen when the watchmen themselves stop following the rules?
That is the question of 2026.
Thanks for joining us on The Deep Dive. We'll see you next time.